can be a reasonable thing to do.
Mr. Chairman.
I call Honourable Phil Goff.
Mr. Chairman, I'd just like to pick up on a couple of points that my colleague David Clendon has made. This legislation, in my view, is not about saying that people who offend lose all their rights when they go to prison, and they have no rights. And I think that is a misconceived view of why this was introduced, and I guess I'm in a reasonable position to know why it was introduced because I did the introduction. And what I said when I introduced this bill, I still believe, and I want to read it out because I think it's pertinent. Most people believe that it is wrong that offenders should be compensated for wrongful treatment, but in turn are not required to pay restitution to the victims they harmed. This arose from the Tonoa case and the behaviour modification regime. That regime was wrongful and it has been done away with. But the people that were in there were amongst the worst offenders. The damage they did physically and emotionally to their victims was intense, and they were going to collect tens of thousands of dollars for their rights being harmed. I didn't believe then, and I don't believe now, that if you have harmed somebody else and you get a windfall compensation, you shouldn't be required in turn to compensate your victims. Part 1 of this bill keeps that provision in place, and I believe rightly so. Look, the thing to do, I'm not arguing at all that the Corrections Department is above the law. If they break the law, they need to be called to heel. They must operate under the law, and there are provisions that enable that to happen. When we put the Corrections Bill through in 2004, that set up an internal complaints procedure. I disagree with David Clendon that that doesn't work. We also put through in 2007, under the Crimes of Torture Act, and the role of the Ombudsman as designated as the National Preventative Mechanism, where 2 inspectors appointed by the Ombudsman regularly go through the places of the prisons to examine the conditions and the treatment. It's putting the fence at the top of the cliff, not a compensation regime at the bottom, that is really important. So the first point is that. The second point is this legislation actually does not prevent any claim for compensation being accepted by the court. The court simply has to do a number of things first. They must first consider whether there are remedies other than compensation that should be employed in dealing with a claim by the prisoner. They must consider whether the prisoner made reasonable use of the complaints procedure and wasn't trying to milk a system, and that's fair enough. And they said that compensation should be reserved for exceptional cases when it was necessary to provide effective redress, and that's fair enough, Mr. Speaker. So for those reasons, I'm comfortable with the fact that this bill remains in force. What I'm not comfortable with, Mr. Speaker, and what Part 1 of this bill doesn't address, is that we are limiting the payments of compensation to victims by criminal offenders to an ever-decreasing number of people. Hopefully, when we stop abuses that might occur within the correction system, there will be no grants. But does that mean to say we do not have to look at the wider problem, which is that most victims never receive a cent in reparation or compensation from their offenders? So if we've got inmate A that wins lotto and gets $1 million, does that mean to say he should never have to pay back that money to the victim that he did so much damage to? The other example I used, Mr. Speaker, is the example of a white-collar offender, because they do have the human resources that would enable them ultimately to compensate their victims. Part 1 does not address the problem of the privileged white-collar offender who goes to jail for 2 years, gets out, goes back to living in the mansion, driving the flash car, having all sorts of resources in the family trust, and leaving thousands of victims of his offending that robbed them of their life savings of ever being able to get compensation from their offender. And in the original legislation, we had sunset clauses, and those sunset clauses called for a review. This part does not actually act on the original legislation. Mr. Chairman,
Honourable Phil Goff.
Mr. Chairman, it does not provide for an extension of a system that looks to the interests of the victim. I'm in the position of criticising this government because it has overlooked the opportunity to do something meaningful to help thousands of victims of criminal offenders who never get reparation, who never see restorative justice, where the offender is never required to put it right for the victim. This measure is supported by us because in a very limited range of cases there is a good cause to say that if the offender gets compensation from the state, they may have to pay that to their victim, but it does not say that the vast majority of offenders, when they have the ability to do so, to repay their offender, to make reparation, this bill does nothing to allow justice to happen in that way. The bill that went through the House originally asked for a review. The government failed at each time when we had to extend the legislation ever to put that review into effect. They failed to use their imagination. They failed in terms of commitment and determination to do something on behalf of victims, and that is why this is regarded by the Labor Party as weak, as half-hearted and as inadequate. Yes, what it keeps in place is okay, but it does not extend what it put in place. It is not wrong to expect of any criminal offender, blue-collar or white-collar, if they are in a position to do so, to make reparations to their victim. They may not be in the position to do so at the time of sentencing or while they're in prison, but if the circumstances arise where it becomes possible for them to provide compensation, then surely they should be required under common sense and any principle of justice to set things right for the victim. Time and again we have heard the rhetoric on the election trail about the need to look after the interests of the victim, when this national government had the opportunity to do a review, to find ways that we could require the offender to compensate the victim. They came up short. And in the course of this debate, we have not heard from the Minister, and perhaps the Minister would like to address this, why the government did not utilise the opportunity provided under the legislation for a review, to do a review, to consult with the opposition, as the Minister at the time promised, and broke that promise, reneged on that promise. The government has been complacent. They've said, well, we'll keep this in place. Labor introduced it. We'll keep it in place, but we won't do anything more. And that relegates thousands of victims across our country to be in a position of never having hope that they will get a fair redress of the injustice done to them by requiring the person that did that injustice to set things right. What more could we ask from a system of justice than it restores the position of the victim? This is a lost opportunity. This maintains the status quo. It does not extend it. It relegates compensation payments to an ever-dwindling number of people that might get compensation because of breach of the state of its responsibilities. It does nothing to protect or enhance the position of the victim. And that's why, while we will support it because it keeps in place a limited measure that I introduced, it does not take the opportunity to extend it to provide a better, a fairer, a more just outcome for victims. Shame on the government for not taking that opportunity.
Mr. Chairman.
I call Dennis O'Rourke.
Thank you, Mr. Chairman. I feel that there